Hi everyone, my name is Kate Halifax and I am part of the real estate dispute resolution team at Harrison Clark Rickabees. This is the second video out of three looking at COVID 1 year on from a number of different perspectives. This one is covering off, is looking at things from a tenant perspective. So if you are a tenant, as a result of COVID, you decided you want to get out of your lease for whatever reason, it could be a number of reasons. What are the available options to you and what should you be thinking about? So to talk about this topic, I am joined by Andrew Walker. Andrew heads up the real estate dispute resolution team at HCR. So Andrew, from your perspective, what do you think tenants should be looking out for if they want to get out of a lease? What are some of the key considerations and things that they should be looking for and thinking about?
I think the first thing is actually to look at the lease, because the lease might give them a right to get out of the lease. For example, a break option. And then if that is to be exercised, it needs to be exercised very carefully and entirely in accordance with the option. So that's one thing. Another thing would be a surrender, but that would need to be agreed with the landlord. And who knows whether the landlord might want some form of compensation to agree that the lease comes to an end early. The beauty of those two options, it will bring the lease to an end and end liabilities. The other thing is to check, if you don't want to follow that route, is to check the marketability of the premises. How much of a market is there for these premises? Can you find someone who will take an assignment of the lease or take a sublease of the whole of the premises? But that would leave the tenant on hook going forward, but it would reduce the liabilities obviously straight away. There may be the ability, and it depends on if it's a corporate tenant and the corporate structure, you could consider liquidating the tenant company. That's quite an extreme step to take and might have ramifications for finance obligations within that tenant company or the group company of which the tenant is part, and there could be reputational concerns. But I mention it just to have it in the background because it might be something you might want to use in your negotiations with the landlord to encourage the landlord to agree or surrender, or to try to reduce the amount of compensation you might have to pay to the landlord. But I think those are the obvious points. Kate, I mean, are there any other thoughts from your point of view on what a tenant could do?
I think just in terms of what you said there and picking up on some of those points, breaks in particular. I mean, whenever someone comes to us and says, look, I'm a tenant, I want to exercise a break, we're like, right, okay, first thing you need to check, is it conditional? And by that, I mean, does a tenant have to comply with certain conditions for that break to be effective? And one of the things that landlords could potentially do in the current climate is try to be slightly more aggressive. Sometimes landlords can have the ability to waive break conditions. They may not decide to do that, particularly if they think the break conditions are particularly onerous and that a tenant is not going to be able to comply with them. And then if the tenant wants to get out of the lease, then it's potentially just going to be an issue of negotiation. Because as you've referred to, Andrew, a surrender takes two. You cannot unilaterally surrender the lease, and unfortunately, so it's very much one of those where you have to have that conversation. And an assignment, again, assignment is quite an interesting one, because again, the starting point is the lease, and quite often a landlord cannot unreasonably withhold consent. So one of the things that will be interesting is whether or not some case law kind of develops that is a bit more COVID specific in terms of reasonably withholding consent and things like that. Because again, we might start seeing landlords being a little bit more bolshy, and they might start pushing back. And you may think, well, what's in it for the landlord? Why would they bother refusing, particularly if a tenant isn't paying rent, for example? But I think one of the main drivers is that if you've got a tenant in there, you're not responsible for rates, for example, and that can have a really big saving. So I think that that's a really important thing to bear in mind. But again, with these things, there's definitely not one size fits all. And I think sometimes it can definitely be a case of increasing your negotiating position as tenant in a number of scenarios. And seeing how the ground lies, really. I mean, Andrew, kind of over the past year, in terms of your experience, because of course, we've been working very closely with landlords and tenants on both sides of the coin. How do you think things have gone? Are you finding that landlords are receptive to these requests? Do you feel that we're being asked to pull a rabbit out of a hat on a number of occasions?
I think in terms of breaks and where the landlord has been served with a break notice, I think without doubt, landlords are taking a fairly firm and in some cases aggressive approach to reviewing whether or not they can defeat that break right. You and I have seen it on some very big cases, and a lot of time and effort can go into that. I think in terms of requests for alienation, requests to assign, I don't think we've seen the landlords being so aggressive, because that's not bringing a lease to an end, and there's continuity there. The landlord's receiving monies, compared with the break where bang, that's it, no more rent from the premises and the landlord having to pick up the business rates. So I think the landlords will fight hard to try and keep, it's an income stream for the landlord, isn't it? Keep that income stream. It's worth investing in fees to try and defeat the break. Alienation, okay, the tenant's got that right, but from my point of view, providing the landlord satisfied with what we call the covenant strength, the strength of the assignee to satisfy the lease liabilities, that's the financial strength, probably the landlord won't want to resist that too much.
Yeah, I think you're right. It's very different where, like you say, with a break or surrender or something like that, it's coming to an end. If you've got someone waiting in the wings, potentially an incoming tenant as a result of a surrender, or you've got a tenant that you want to sign to, then I do agree it's quite a different picture. But kind of coming back to looking at this from a tenant perspective, what I think is particularly interesting is their drivers. As a result of COVID, I think a lot of tenants have had a bit of a knee-jerk reaction in terms of, oh gosh, everyone can actually work from home. I want to get out of space and save some overhead. But I think that as time goes on, and the firm actually did a future workspaces report recently, which actually looked at tenants and landlords' attitudes to the market and what they wanted from their space and the future of the office. I mean, what they want kind of when this is settled might be slightly different, but I think one of the key themes is that people are looking at their space very differently, and tenants are definitely now evaluating what space they need and also what they need from that space. Is it office space? They want more communal working spaces and things like that. And with a lot of those things, they need the landlord's input. A lot of this they can't do themselves.
I think that's right. So in fact, a review of the tenant's ability to carry out alterations to premises will probably become more important. And again, often that's subject to the landlord not unreasonably withholding consent. I mean, but at the highest level, the landlord's position, the tenant's position, to some extent will depend on, again, how marketable those premises are. If there isn't a great market for the relevant premises, the landlord inevitably is going to be more flexible, probably in agreeing terms for example, alterations, and considering potential payment holidays or suspension for a period. It all depends on the premises, because if the premises are highly marketable, I think the landlord perhaps will want to get the premises back. The landlord might want to redevelop the premises. We've seen that. And actually, he really wants the premises back swiftly, but...
Yeah, redevelopment's a key one. I'm not going to talk about that too much because we've got one of our planning colleagues touching on that in video number 3. So we'll save that one. But yeah, you're completely right. I think that whatever perspective you look at kind of the past year from in the property sphere, whether it's the landlord's perspective, the tenant's perspective, there's a number of common themes here, and it's going to come, a lot of it boils down to whether or not the parties are prepared to work together, what the parties' aims and objectives are, and what they want out of their property as well. And I think that a lot of that is still developing. I think we're going to see a lot of tenants. Yeah, I think a lot of tenants are still going to want to get out of property going forward. But whether or not that's going to completely extinguish their driver for property going forward, I'm not sure. Like I said, I think we're seeing a bit of a knee-jerk reaction at the moment, and for obvious reasons, tenants are looking to make a bit of a saving. But whether or not this trend continues, I'm not so sure. I think that I'd like to think that, particularly from an office working perspective, I really like working in the office. Personally, I'd like to think it always has its place. But I think we'll wait and see. Do you have any comments or thoughts on that?
Well, I think you're right. I mean, I think that, there have been, COVID has had and will have a permanent impact on real estate, but its impact will be different depending on the types of property. And excuse me, the reality is at the moment, no one quite knows the future and what's going to happen and the extent of restrictions. And also there have been changes, as you rightly say, in the office environment. There is arguably going to be less need for so much office space in the way we currently have it. But then real estate will evolve. And we've seen on the high streets, for example, there is talk now of having more resi use. But then there's also a lot of support for independent shops. Some of the supermarkets might, where they're not in great locations, they're looking to convert to resi. It's flexible. You have to look at each real estate situation and suss what's best, but accepting that there is an evolving situation with real estate use. As lawyers, we've got to adapt to that as well and take it on board whenever we're giving advice.
Yeah, exactly. And I think, in terms of advice, a tenant picking up the phone and saying, look, I'm in a bit of trouble here. I need to get out of this, because quite often the property interest is one of its largest overheads. So I think that's why it's been in the spotlight so much recently, because it's a bit of an obvious go-to recently. So yeah, I mean, I completely understand the drivers for that. But like I said, whether or not we're going to see this going forwards or as much of it, I'm not so sure. But well, unless you've got anything to add, Andrew, I think we'll leave it there from a tenant's perspective.
No, I don't really have anything to say. It's an evolving situation. We're going to be monitoring it closely. And actually, do you know what? It's going to be interesting. Life goes on.
Yeah, exactly. And tenants have options at the end of the day, as we've highlighted. Some rights it may be able to invoke contractually, and others may take two. But I think that the important thing, take legal advice, assess all your options, and see where it comes out. So I think that's a fairly positive note to end it on. So I think we'll draw a line under it there. Thank you very much, everyone, for joining, and thank you, Andrew, as well.